Are you ready to go?
Yep.
Excellent. Okay. Okay, good evening, everybody, and welcome to the Wednesday evening Fletcher Day online seminar. Tonight, we are looking at guidance for employers' right to work checks. We are joined by Onaiza Khokhar, who is a consultant solicitor on the immigration team for Fletcher Day, and she's going to be talking us through some important guidance for employers on right to work checks. As always, if you have any questions, please feel free to put them in the Q&A or chat facility in the bottom toolbar. If it's something you would prefer not to ask in an open forum, please feel free to email Onaiza, and it's onaiza.khokhar@fletcherday.co.uk, and you will see her email on the screen at various points during the presentation, and she will be happy to answer these questions for you. Without any further ado, Onaiza, I will hand over to you. Please start your presentation.
Thank you, Julie, and good evening, everyone. There's a lot on this slide about me, but I won't spend too long about that. A quick one. I started working in the field of immigration law in 2009, and I qualified as a solicitor in 2012. Since then, I've only practiced in immigration law. So I'm a self-obsessed immigration addict. Today, I'm going to provide you with guidance on the topic of right to work checks. Now, that's not specific to those who want to sponsor migrants. It's for any UK employer. So like I said, all UK employers have a responsibility to prevent illegal working. You do this by conducting right to work checks before you employ someone in order to make sure that the individual is not disqualified from carrying out the work in question by reason of their immigration status. By adequately carrying out the checks, employers avoid being liable for civil penalty. This is called establishing a statutory excuse against liability for a penalty. This means that if the Home Office find that you have employed someone who does not have the right to work, but you have correctly conducted the right to work checks, you will not receive a civil penalty for that illegal worker. Now, that's quite important. In line with government guidance, the check can be carried out as late as on the first day of employment before they commence work. However, I highly recommend doing it further in advance. This is so as to ensure that there are no issues, as employers wouldn't want to be left in a position where right to work checks can't be satisfied on the day, and this ends up delaying the start date of employment, or in the worst case, means that the employer actually needs to start a new search for an employee if it comes to light that the individual never had the right to work. If an employee's visa or right to work is temporary, then the employer must carry out a follow-up check before their current visa expires. So, for example, if the individual is British or holds indefinite leave to remain or settled status, there is no requirement to carry out any further checks during the course of their ongoing employment. If, however, they had a temporary visa, for example, a spouse visa, which is valid for 2.5 years, you would need to ensure that you diarise to carry out a follow-up check shortly before the visa expires. You need to ensure that it's diarised in such a way that if your HR staff changes, then the new HR will already be aware of the relevant date. So it's not in the HR employee's personal calendar, which is not going to get moved on, for example. There are two types of right to work checks, so it's manual and online. The type of check you conduct will be dependent partly on the status of the individual that you want to employ, and sometimes it's based on the individual's preference. I'll now go into more detail on each type of check. A manual right to work check is often completed for UK or Irish nationals who can use their passport as their proof of right to work. It's also used for anyone else who can't or doesn't want to prove their status online. There are 3 steps to conducting a manual document-based right to work check. You need to complete all 3 steps before employment commences to ensure you have conducted a check in the prescribed manner. This is in order to establish a statutory excuse. The three-step process is to obtain, check, and copy. So you need to obtain the original versions of the acceptable documents, check the documents are genuine and that the person presenting them is the rightful holder and allowed to do the work that you are offering. And 3, copy the documents clearly in a format which cannot be manually altered, and record the date on which the check was made. I'll now advise on the 3 steps in more detail. So back to the first step of obtain. The acceptable documents that you must obtain are listed on the right to work checklist. The documents you may accept from a person to demonstrate their right to work are set out on 2 lists, List A and List B. List A contains a range of documents that you may accept for a person who has a permanent right to work in the UK. No further checks are required for those individuals. List B contains a range of documents that you may accept for a person who has temporary right to work in the UK. For those who fall under this list, you'll be required to conduct a follow-up check in order to retain your statutory excuse. The follow-up check should be undertaken in the same way as the original check. So, step 2 was check. The responsibility for checking the document is yours as the employer. So whilst you may delegate that responsibility to a member of staff, you will remain liable for the penalty, even in the event that the individual is found to be working illegally and the prescribed check has not been carried out correctly. You may not delegate this responsibility to a third party, such as your immigration advisor. When you are checking the validity of documents, you should ensure that you do this in the presence of the holder. Now, that can be a physical presence in person, or it could be via a live video link. However, in both cases, you must be in physical possession of the original documents. For example, an individual may choose to send you the documents by post or by courier to enable you to conduct the check with them over a live video link. You must not, however, rely on the inspection of the document itself over the live video link. So you can't have them hold up their passport to show you. And you equally cannot have them scan a copy or post you a photocopy or anything like that. It has to be the original document you're looking at. If you're given a false document, you will only be liable for a civil penalty if it's reasonably apparent that it is false. So if it's an amazing counterfeit passport, which, passed the inspection that, they traveled in on it and UK Border Force hasn't managed to notice that it's a counterfeit, you could get away with not being responsible for having seen that it was counterfeit. But you need to take reasonable steps to assess the documents. So you must, for example, check that the photographs and dates of birth are consistent across the documents and consistent with the person's appearance. This is in order to detect impersonation. You need to check that the expiry dates for permission to be in the UK have not already passed. So they might have had the right to work in the UK, but it might have ended. So you need to ensure that you're not employing them for a date past the validity. You need to check for any work restrictions to determine if they are allowed to do the type of work on offer. For example, students usually have a limited permission to work during term times. So for them, you must also obtain, copy, and retain details of their academic term and vacation times, covering the duration of the period of study in the UK for which they'll be employed. You must also check that the documents are genuine, in that they've not been tampered with and that they belong to the holder. For example, you could look out for damaged or substituted pages. You should check the print quality, and you can even check for watermarks by viewing the page with a light source. Lastly, you must also check that the reasons for any difference in names across the documents can be explained by providing evidence. For example, a marriage certificate, divorce decree, absolute, or a deed poll. These supporting documents must also be photocopied and a copy of those retained. So moving on to the final step, to copy. You must Make a clear copy of each document in a format which cannot be manually altered and retain the copy securely, either electronically or in a hard copy. You must also retain a secure record of the date on which you made the check. It's important to note that simply writing a date, so for example, 20th October 2021, on the document does not itself confirm that it is the actual date on which the check was undertaken. You can, however, write the following example of words and say, the date on which this right to work check was made is 20th of October 2021. That confirms that this was the date the check was indeed made. All copies of documents taken should be kept securely for the duration of the worker's employment and also for 2 years afterwards. The copy must then be securely destroyed. You should also be able to produce these documents quickly in the event that you're requested to show them to demonstrate that you've performed a right to work check and that you've retained a statutory excuse. Going into the specifics of what to copy, it can get quite complex. So for example, for a passport, you need to retain a copy of any page which holds the document expiry date, the holder's nationality, date of birth, their signature, the leave expiry date, biometric details, their photograph, and any page containing a current UK visa or entry stamp. It's quite a bit. Often it's on one page, but it's your responsibility to check if it's a passport of the country that's new to you. It could be on 2 separate pages. You need to just be aware of that. It was previously the case that you would need to take a photocopy of the front cover of the passport. That's no longer the case. For all other documents, you must retain the copies of the document in full. So for example, for a biometric residence permit or a biometric residence card, you have to take a copy of the front and the back of the card for it to be a complete document. Online checks are required for individuals who have digital proof of their immigration status in the UK, sometimes known as an e-visa. This is an example image of what you would expect to see if you're using the online checking service. Currently, the online service supports checks in respect of those who hold any of the following types of visa. So in the format of a biometric residence permit, a biometric residence card, status issued under the points-based immigration system, British nationality overseas visa, frontier workers permit, status issued under the EU settlement scheme, or if they hold a digital certificate of application to the EU settlement scheme, which was issued before the deadline to apply, so that's 30th of June 2021. That matter we will talk about in a little more detail later in the presentation. There are 3 basic steps to conducting an online right to work check. So step 1 is to use the Home Office online right to work checking service. You're required to know the individual's date of birth and their share code. A share code is something they would have obtained online within the last 30 days before giving that to you. In terms of the individual obtaining their share code, it's a fairly simple process. However, if you have an employee who's unsure on how to do it, how to obtain it, then you can feel free to point them in my direction. I'll be happy to guide them on how to access their share code, and it's not something I would charge for. It was a simple question. Again, you must ensure that you only employ or continue to employ an existing employee if an online check confirms that they are entitled to do the work in question. So step 2 is that you must satisfy yourself that the name and photograph of the online right to work check is of the individual that's presenting themselves for work. Again, just like with the manual check, this can be done either in person or via a live video link. Step 3 is that you need to retain a clear copy of the response provided by the online right to work check. Again, as with the manual check, you need to store the response securely, either electronically or in a hard copy for the duration of their employment and for 2 years after. The file must then be securely destroyed. You must ensure that it's the profile page that you retain confirming the individual's right to work. So just going back to the previous slide for a moment, you will see that this is the page that includes the individual's photo and date on which the check was conducted. At the bottom of this screenshot, you will see that you have the option of printing the profile or saving it as a PDF. It's important that you give employees every opportunity to demonstrate their right to work. You cannot insist that they use the online service because it's more convenient to you. Equally, you cannot discriminate against those who choose to prove their right to work by presenting you with documents valid for a manual check rather than an online check. Now, moving on to recent changes that have taken place to right to work checks. These are applicable to EEA and Swiss citizens due to something that you may be familiar with. It's something called Brexit. When the UK left the European Union on 31st December 2020, this meant the end of free movement law. On 1st of January this year, a grace period of 6 months began, during which time eligible EEA and Swiss citizens and their family members who were resident in the UK by 31st December were permitted to apply to the EU settlement scheme. This grace period ended on 30th of June this year. Accordingly, since 1st of July, EEA Swiss citizens are no longer required to hold they're required to hold valid immigration status in the UK in the same way as foreign nationals. They can no longer rely on EEA passport or national identity card to prove their right to work. As discussed earlier in the presentation, Irish citizens are an exception to this. They can continue to have unrestricted access to work in the UK, and so they can continue to prove their right to work using their Irish passport or their Irish passport card. The majority of EEA nationals looking to arrive in the UK to work will look to apply for sponsored work visa if they're eligible to do so. Employers will need to hold a sponsor license to employ individuals coming to work in the UK under these visa types. I'll go into more detail on the sponsored routes in my next slide. A sponsor license is not required to employ EEA nationals who hold a visa in a different category, which also permits work. For example, if they hold a visa as a partner of a person who's settled in the UK. Since the start of the EU settlement service in March 2019, over 6 million applications were made, with many of those submitted quite close to the deadline. I know I had a rush of clients instructing me to assist with their applications in the final month of June this year. So understandably, many of those 6 million applications are still pending. As such, the EU settlement service applicants and joining family members are able to take up employment while they await the outcome of their application. So in the case of pending applications where a prospective employee has submitted their application before the deadline and they've been issued with a certificate of application, you must first check whether it is a digital or non-digital certificate. If it's digital, then you need to carry out an online check. If it's non-digital, then they will have received either an email or a letter advising them how prospective employers can request information about their right to work from the Home Office Employer Checking Service, or ECS for short. Where a prospective employee has a certificate of application confirming a valid application to the EU Settlement Service made after the deadline, employers should also verify this with the ECS. A valid check using a certificate of application gives a statutory excuse for up to 6 months, or less if a decision is known and checked before that period ends. As discussed in a previous slide, if you want to sponsor workers from outside of the UK resident labour market, you'll need to be a Home Office licensed sponsor. This will enable you to recruit workers from anywhere in the world. And so because post-Brexit, this is now applicable to those who arrive in the UK from the EEA, there has been a huge influx of companies applying for a sponsor license in order for them to be permitted to hire these EEA nationals. I've been instructed to assist with more sponsor license applications in the last 10 months than I have in the entire decade prior. The reason for this is as it's a must in order for a company to hire the majority of new entrant EEA workforce going forward. So for those who've entered post-Brexit, this is usually the only way you can actually sponsor them to work. There are two main sponsored routes, which are the skilled worker visa and the intra-company visa. A skilled worker visa allows an individual to come to the UK or stay in the UK to do an eligible job. It's a route which can lead to permanent residence in the UK. An intra-company visa is for existing employees being transferred from their overseas branch to the UK branch of the same company on a temporary basis. So for global companies. I say temporary because this route does not lead to permanent residence in the UK. So you need to have a good think if you're looking to have someone to the UK for 3 years. Do you want them to have the ability to stay permanently after that? If the role might extend, then you might, instead of looking at the intra-company route, you might want to look at the skilled worker route instead, to give them that option of permanent residence at the end of the 5 years period. For both of these visa types, the applicant must have a job offer from a Home Office licensed sponsor. They must have a certificate of sponsorship from their employer. So a certificate of sponsorship, COS for short, holds information about the role they've been offered in the UK. They must do a job that's on the list of eligible occupations, and they must be paid a minimum salary. How much depends on the visa type and also the type of work they do. So if you have any questions on that minimum salary for a specific role, do reach out to me and I can help you along with that. Additionally, for the skilled worker visa, as the route leads to settlement, the applicant must also prove that they can speak English to the required standard. You can usually carry out either an online or manual check for your sponsored employees. A right to work check should be carried out for every individual you employ. As the employer, you're liable for the civil penalty, even if the actual check was performed by a member of your staff. If you are found to be employing someone illegally and you have not carried out the prescribed checks, then you may face sanctions, including but not limited to a civil penalty of up to £20,000 per illegal worker. In serious cases, a criminal conviction carrying a prison sentence of up to 5 years and an unlimited fine, closure of the business and a compliance order issued by the court, not being able to sponsor migrants, and seizure of earnings made as a result of illegal working. So as you can see, the penalties can be quite severe. You will not receive a penalty, however, if you have that statutory excuse that I've been talking about. You will not obtain a statutory excuse if your check was carried out by an individual who is not employed by you. So for example, a third party like a recruitment agency or your professional advisor. You will not obtain that statutory excuse if it's reasonably apparent that the person presenting the document is not the person referred to in that document, and that's even if the document itself is genuine. You will not obtain a statutory excuse if you know that the individual is not permitted to undertake the work in question, or if you have reason to believe that the documents are false. The process of carrying out right to work checks is not complex if you follow the guidance provided. In order to avoid sanctions, I recommend the following. Keep up to date with the right to work check guidance published by the government. In an earlier slide, I've given the link to the relevant page for this. However, it's not sufficient to simply save and print the page and use it. You must always be sure to revert back to the web page, as the checklist can be updated at any point in time, and employers are expected to always use the current checklist. You must also ensure that you have the correct procedures in place to carry out adequate right to work checks. This includes training your HR staff and any staff with delegated responsibility for the recruitment of employment of individuals. Finally, if you're unsure on anything, ask. You can contact me if you'd like your team to receive training directly from me on right to work checks. I also offer a service of conducting audits to ensure that right to work checks have been carried out correctly. I recommend this service to anyone with concerns as to if your company has been carrying out the checks adequately. I'm also experienced in assisting with sponsor license applications, which, as I've explained, is now needed to sponsor new entrant EEA nationals post-Brexit. And I also assist with skilled worker and intra-company visa applications, and to be honest, most other UK immigration application types. Julie, do we have any questions?
It doesn't appear so. It looks like you have explained everything very thoroughly, Onaiza, so thank you very much for that. If you do have any questions, or you, as we said earlier, if you don't wish to ask them in an open forum, as you can see on the screen there, Onaiza's email details are onaiza.khokhar@fletcherday.co.uk, and Onaiza will be happy to answer any specific questions that you have regarding this topic. So thank you, Onaiza, for your time.
Thank you.
You very much, everyone, for joining us, and we look forward to seeing you again soon. That is it for this week. As you can see from the screen there, thank you, Onaiza. We have JCT Standard Form Design and Build next week on Wednesday at 8 a.m. Exterminate, which is contractual and common law termination, on the 27th, next Wednesday at 6. And then Novation, which is the last one for October, at 6 p.m. on Thursday. If you would like a place or to log in, the login details for any of these, please don't hesitate to email us on seminars@fletcherday.co.uk. And as earlier, if you have any questions for Onaiza, please don't hesitate to email her directly. The presentation slides for this evening for reference will be up and available to download from tomorrow morning onwards. Thank you very much, everyone. Thank you, Onaiza. And we look forward to seeing you all again very soon. Thank you.